Good morning, all. Hope you're doing good this morning. It's good to see everyone. So we are here for the pre-hearing conference for new rules and amendments to the minerals rules regulations of the Colorado Mine Land Reclamation Board for hard rock metal and designated mining operations, specifically implementation of HB 2019-1113, definition of production, temporary cessation process, and various rules and updates and edits. So I'll go ahead and introduce myself. So I'm Jeff Graves. I'm the pre-hearing conference officer on behalf of the board. I don't know if we want to go through introductions of staff. I believe we also have our board attorney on this morning. Let's go ahead and just do introductions of staff, and then I'll go through the parties list to see who else here. So Chuck, do you want to introduce yourself?
Yeah, I'm Chuck Koyman with the AG's office representing the board.
We have Jeff Fugate.
Good morning, everybody. Jeff Fugate with the Attorney General's office representing DRMS, who is staff to the board in this rulemaking.
And then in the room we have,
hello, it's Russ Means, Minerals Program Director.
good morning all, Michael Cunningham representing the division. And then I think we have a number of DRMS staff appearing virtually. Who do we have?
This is Travis Marshall with DRMS.
Thanks, Travis. I think that should be it for DRMS staff. So I'll go ahead and go through the list of parties. And if you'll just let me know if you're here and who you are representing that organization. So I have a list of 11 parties that the division posted online. I'll go ahead and start with Ouray Silver Mines. You here?
Yes, I'm Poppy Staub. I'm the VP of Environmental and Government Affairs for Ouray Silver Mines. Good morning, everyone.
Morning, thanks, Poppy. Colorado Mining Association.
Yes, this is Jim Sanderson. I'm here with Stan Dempsey. As you know, those of you who've looked at the pleadings, CMA joined with other companies that are CMA members in filing a unified pre-hearing statement, even though individual companies filed for party status.
Mr. Sanderson. Energy Fuels.
Hi, good morning. This is Julia Hoffmeyer. I am corporate counsel for Energy Fuels, and I believe Scott Bakken is also on the line. I'll let him introduce himself.
Yeah, hi, good morning, everybody. This is Scott Bakken, Vice President, Regulatory Affairs for Energy Fuels.
Okay, thank you. Western Small Miners Association. Sure. Okay, so
I think that Rich Ziegler is on. I see his name, and he's a party. They joined with CMA in the unified pre-hearing statement. I don't know, Rich, if you want to say hello.
Rich, are you able to unmute? I did see Rich, so I'll just mark him as
Yeah, I see he may be having technical problems on his end there.
So I also have Inform et al.
Oh, I'm sorry. Yeah, the several conservation groups that have joined together under one filing. This is Travis Stills, Energy and Conservation Law. Jeff Parsons has a trial today, so I'll be handling the conference for today. Thank you.
Thanks, Travis. Uranium Leasing Program, DOE.
Yeah, this is Debbie Barr. I'm Department of Energy Office of Legacy Management, and I'm the Uranium Leasing Program program lead. We also have another of our DOE folks online, Ian Schaefer. Do you want to introduce yourself?
Sure, thanks, Debbie. Ian Schaefer, and I am currently the reclamation lead for activities on uranium leasing tracks. Thank you.
Thanks. We have Integrated Production Resources, and I see that's also Rich. So I don't know if you were able to unmute yourself, Rich, or not, but go ahead and mark you as here. Newmont Mining.
Morning, this is Justin Ragland, Sustainability and External Relations Manager at Newmont's Cripple Creek and Victor operations.
Thanks, Justin. Western Uranium and Vanadium Corporation. Pinion Ridge Mining LLC. See you, Rich. Okay, so nobody.
This is George Glazer, Pinion Ridge.
Oh, okay.
Thank you, George.
Yeah, thanks, George. And then we have Nuvemco.
Hello, everyone. Paul Szilagyi, Manager and CEO, Nuvemco LLC.
Thanks, Paul. So it looks like we have at least 10 of the 11 formal parties here this morning. So kind of the game plan for today is to figure out some times for the board presentation, just go over a few things in terms of process, kind of how we're going to divvy things up. At this point, I don't know if there's anything the division wants to kind of introduce as we get into this or not.
I think we'll be.
Okay. Okay. So really the pre-hearing order is to set the order of presentations before the board and to outline the process so that the board can hear everybody's comments in a timely fashion, an organized manner in which they can then do deliberations to make those rules. So we've already established parties. I know everybody, or at least we had 4 different pre-hearing statements submitted by formal parties. I believe those pre-hearing statements were from Inform and others they are representing, also from CMA. We had submittal from DOE Legacy Management, and then also I believe from Nuvemco. So those were the 4 pre-hearing statements that were submitted in a timely fashion. Let's see. So rights and responsibilities. I mean, the formal parties, obviously we're going to be talking about presentations before the board. And so you have the opportunity to present evidence before the board, actually make your comment related to the proposed rules, call witnesses associated with those, with your comments to make your case. Just keep in mind the board does have the authority to limit any irrelevant testimony and anything that might not be pertaining to the rules at hand that were posted. So I guess we'll go ahead and get into discussing kind of the order of presentations and the associated time. I know in the last board meeting, there was the board gave some emphasis to trying to keep this to a 2-day hearing if possible. So we're going to be looking at trying to divvy up the time in 2 different days with kind of timeframes between 9 o'clock and 5 o'clock on those days, obviously with time for lunch and breaks within that, within each one of those days. And so I think that to kind of keep things organized in a fashion that allows the board to hear kind of concise arguments related to each one of the topics, I think it makes a lot of sense to divide up the testimony or the comments kind of by day and by issue. And so I think on kind of day 1, so that Wednesday, we were thinking about having the discussion pertaining to HB 2019-1113 on that day. So reserving Wednesday for discussions related to 1113, and then having day 2 as discussions pertaining to temporary cessation and production. Does anybody have any concerns about just kind of dividing up the presentations that way? Okay.
Mr. Chairman?
Yes.
Jim Sanderson here. I'm a bit out of order, but I want to not forget to raise a couple of points of clarification that we have about the filings that have been made already and the upcoming rebuttal statements that are due in about 10 days. Would that be out of order to ask those questions now, or do you want to wait until later?
Do you think those questions will impact time allocation or?
Well, they might.
Okay.
I can wait. Go ahead. Sorry to interrupt you.
Oh, no, that's okay. I don't think it matters at this point what order we go in to discuss things.
We were going to discuss the upcoming dates and stuff for submittal of rebuttals and stuff that the schedule moving forward. So maybe that time it might help and stuff too. So
yeah, I kind of had the discussion of kind of the upcoming dates towards the end of today's time, but why don't we go ahead and just get into time allocation, and then you can bring up your point. If that impacts how we've divided things up, we can go back and readdress that if we need to. So I think initially what we were thinking about on each day was to allow some time for non-party comments. Obviously, the non-party comment submittal time is not for another almost 2 weeks to actually request to present before the board. So we don't really know what we're going to have from a non-party comment standpoint at this time. But I think if we allocate about 30 minutes on day one, with the potential to allocate some time on day two if necessary, limiting those non-party comments to about 3 or so minutes, I think should hopefully get through any comments that we do have and still allow us plenty of time for the formal parties to actually present their case and allow the board to have time to do deliberation. So we'll probably start off with the non-party comments on day one.
If I may just
Comment?
Yeah, as far as the non-comment or non-party, worked with a lot of groups and a lot of hearings with those kind of comments, and 3 minutes is about a minute and a half, a minute and 45 to say hello and greet the board, and then nothing really is able to get said. I would, suggest moving that to 5 minutes. Oftentimes, if you do 5 minutes as opposed to 3, it will also make your day go smoother, and you won't have to shut down people who are frustrated at the time limit. So just a suggestion and some input based on having done a lot of these. And I know you all have done a lot of these too, but 5 seems to be folks I work with would say that's still not enough, but I think it would make the day go well better than 3.
Okay, and we could certainly take into consideration 5 minutes. I think the important part is giving the most time, I think, to the formal parties that did submit comments and propose changes to the rules, but certainly not shutting out the public and still allowing them sufficient time to make comments. So I guess a lot of this is obviously going to depend on how many non-party commenters we have that request time before the board, and we'll have to kind of adjust based on that. But
you're going to do an amended order to adjust for that possibly?
Yeah, I mean, and that's something I was going to discuss towards the end, just recognizing that based on the submittal times for different things, there's potentially a need to revise the pre-hearing order that we developed today. I mean, it's merely a draft at this point. Obviously, it's not an order until the board accepts it. But so depending on if we get a significant number of non-party comment requests, then we may amend the pre-hearing order to accommodate those. So I'll take your comment into consideration in terms of the 5 minute window, and we'll just kind of see what we have in terms of non-party requests for comment. That works.
I can't provide any insight on how many we kind of expect to come in. I just don't have any information on it, or I would, but that sounds like a fair way to go forward.
Okay. So I think to tee things off after the non-party comment would be the DRMS presentation to the board. And I think in conversations with DRMS, I think an hour on day one to kind of frame the rules and the amendments to those rules for HB 1113 That's what you guys requested, was about an hour of time on the first day.
Yes.
Okay. And then I think probably go with the conservation group presentation next, following the division. And kind of based on the comments submitted for 1113, does an hour sound like an appropriate amount of time to present your comments related to 1113 for the conservation groups? Travis?
And we're going with a process that has, I'm trying to see a note here I had. Will it be an opening and then a presentation and rebuttal, or are we just going straight into the into each portion as you divide it up? Is there going to be any sort of opening presentation for the entire rulemaking, a statement on that?
I don't think so. I think what we were looking to do was combine kind of the opening and comments and rebuttal into your presentation. So you have allocated a time for comment, which would include pretty much, your opening, the heart of your discussion as related to the comments submitted in that pre-hearing statement. And then any potential rebuttal you have based on the rebuttal comments that were submitted by all the other formal parties. I believe that's by May 5th is when those rebuttal statements are in. So you'll at least have an opportunity to rebut, obviously the comments that have already been submitted as part of that kind of presentation block, if that makes sense.
Okay, so just so I'm clear, and I think this kind of flows down to everybody else's, so
Sure.
hopefully I'm asking questions that'll.
No, that's great. Go, fire away.
So it'll be a presentation block, address the written materials, the case in chief, if you will, and then each party will have an opportunity for a rebuttal later after everyone has done their presentation, and there'll be 2 presentations per party. Is that correct?
I think we were looking at just 1 presentation per party, so it would all be grouped together as part of your block. So really, there's not a rebuttal to somebody else's comment period. So whatever your comment is and rebuttal to those existing pre-hearing statements that were submitted to the division, that's all included in your block. So there's not really a presentation and then an opportunity to rebut. It's kind of a presentation block associated with your submittal and any rebuttal to previous submittals by the other parties.
Okay. I was sort of anticipating that there would be rebuttal on the day's testimony and evidence. Otherwise, it goes in unaddressed by the other parties. The opening presentation, I assume there's going to be something in the presentations that aren't in the statements. And I think I'd like to ask you to consider at least a rebuttal that would address what's been presented on the day.
Okay, does anybody else have a similar position to having specific rebuttal time? Or if folks are comfortable with kind of a full block of time to allocate for your presentation?
This is Jim Sanderson again. I tend to agree with Travis, mainly based on experience in a number of different forums with boards and commissions. You have the pre-hearing statement, which is what each party is advocating on their behalf to the board. And then you have a rebuttal statement that follows, which has an opportunity to disagree with the main position of another party if they so desire. And it kind of joins the issues. And typically, the order of presentation would be repeated later in the session to allow let's say, Travis's group to rebut what they've heard in the direct presentations of the others. So that, to me, is a more normal way of proceeding in these matters. Otherwise, I think the party has to guess what the rebuttal, what the presentation of the others is going to provide. So I guess I would lean toward supporting Travis's recommendation.
I think Jeff Fugate has his hand raised. Jeff.
Thanks, Jeff. Let me lower my hand here. In kind of putting together, at least kind of talking with Russ and staff about, a hearing process that makes sense. We're looking at a variety of things to try to get this hearing conducted, in the 2 days we have slotted before the board. If any of you listened to the board's comments from I guess it was earlier this month, they were pretty definitive that they wanted to try to get this rulemaking conducted in the Wednesday and Thursday of this week. There was not a lot of interest or availability for this kind of flopping over into that Friday of the 20th. And if this is pushed into June, we do lose some board members who are just not available in June. And so that was some of the direction that staff got from the board, was to craft this hearing order so that it could be conducted over the 2 days the board's available. That makes it difficult for a lot of shuffling of the parties between presentation time and rebuttal time. I think we could do that. I think that there's a way to kind of follow the same order. The order that we have for presentations could then be mimicked for the rebuttal time. But all that's going to come from kind of that whatever the initial time slot is, Jeff, that you had kind of established for the parties. If we're looking at, it sounds like, Jeff, you're going for an hour for staff, maybe an hour for some of the consolidated parties, less time for some of the others. If some of that time is carved out and reserved for later on for rebuttal, I think that's possible. We just have to make sure that we leave enough time for the board to ask questions and deliberate at the conclusion of day one, and then obviously the conclusion of day two. And so with that kind of in mind, with kind of making sure there's enough time for the board to deliberate, I'll defer to the parties on if they would prefer to use rebuttal time as opposed to just presentation time. I guess my final comment is, I'm not sure there's going to be a lot, or that the board is interested in hearing a lot of new testimony that's going to require rebuttal during oral presentations. I think the process here is that the parties' arguments and rebuttal would all be part of the written record that the board will review and parties will review, and that rebuttal could be raised at any time by any party, because you'll have an idea of party positions and arguments based on the written pleadings. So as I said, I'll defer to the parties if kind of a designated rebuttal seems to make sense. Just know that we've got kind of a finite amount of time on each day to deal with these things and still leave time for the board to deliberate.
Mr. Chair, if I can follow up, for the CMA group, I think we're happy to go along with whatever the board, council, and Jeff and you, Mr. Chairman, are inclined to go, and we can make it work either way. I just think it's clear. I would offer this observation that a 5-page double-spaced rebuttal is a fairly short document. That's what your pre-hearing order calls for. And so to do a better job of, Chris, unless you just want a bunch of one-liners, maybe you could expand the allowed length of the rebuttal statement, and then the parties in their presentations would have to focus on what's been in writing heretofore.
Yeah, I'm comfortable with allowing some time for rebuttal. I just think, from a time standpoint, either you kind of get it on the front end or you have time on the back end. We're not going to be able to add a bunch of additional time for rebuttal on top of what's kind of already allocated. So I guess my thought, I'm comfortable with allowing some rebuttal time. Just kind of keep in mind that rebuttal time kind of cuts into the overall time associated with your kind of block. Somebody else have a hand up?
Yeah, again. Yeah, What you just said is more or less what I was going to say. The 60 minutes, we didn't have a problem with. In fact, we'd come assuming we would have about that amount of time divided between a rebuttal and the main presentation rebuttal. I wasn't asking for more. I was just the sequence. And then one other thing to consider, as Mr. Sanderson and I are in agreement, might as well keep that going. I don't know if there's any for the second day, and I know I'm jumping forward, but as you're thinking about time allocations, peeling off a few minutes for closing statements after the parties and the board and the division and the non-parties have commented, it might be helpful to the board. I think it would be something we would like to do, is a short closing statement to say, you should adopt them as proposed. You should adopt these amendments that have come up during the day. We support this position. I don't know. It would be very limited in time. It wouldn't be a closing statement as a review of all of the evidence, but more of an opportunity for the parties before the board goes into the deliberation to have a short, concise statement of position based on what the hearing has brought up.
Okay. No, and I think that's something that we were going to consider. Certainly on the last day was some closing time allocated to the various parties in the division to kind of sum things up, just like you outlined there. I think that would be appropriate. So we certainly have that. And I think, if we're comfortable with, on that first day, kind of having the 1 hour time blocks, and then within that, what are you thinking, like 45 minutes for each of your presentations and then 15 minutes for rebuttal? Does that seem acceptable?
That's what I had in mind. You could leave it up to the parties, but I think a 45-15 is an acceptable split for us. I think that would be a good way to go forward.
Okay. Mr. Sanderson?
Yeah, I think that works. Or you could, as Travis indicated, you could allow each party to divide their time as they feel they need to, based on how the proceeding is unfolding. In other words, not have it rigid 45 and 15.
Okay. I think I'm comfortable with that, just recognizing that, we've got a block of an hour, and I think for each one of the parties. And I've kind of been assuming, and maybe I should not, but on 11-13, we really just have two parties that are presenting. Or wanting to comment before the board? I think we had the group represented by CMA and the group represented by Mr. Stills.
In terms of the CMA group, I've consulted with each of the companies that have individual party status, and they, after reviewing the pre-hearing statements of others, believe that they can present a unified block of time at the hearing. So, they can share the 1 hour that you're suggesting.
Okay, thank you. Yeah, I just want to make sure I'm not leaving somebody out, because I'm kind of thinking we have two.
Now, there are some other parties, Mr. Chair, that you haven't spoken to, DOE and others. I don't know what you're going to deal with them.
Yeah, and I think at this point, I just, for the 11-13 discussion, are there any additional parties that want to have time allocated to them on that first day that I have not already talked to or spoken of? Okay. So we just have the two parties, for lack of a better term. Travis, I'm just going to lump you guys into a conservation party or conservation group. And then we'll have those represented by CMA on that first day. That works for folks. Okay, so we'll go ahead order-wise on that first day. We'll have at least at this point, 30 minutes allocated for non-party comments initially. Then we'll have an hour for DRMS presentation. Then we'll have conservation group go first with their presentation, and that could be, you know, some chunk of that 1 hour time. Then we'll have CMA go with their presentation and portion of 1 hour time. And then we'll follow up with, let's see, rebuttal from conservation and then rebuttal from CMA.
Do we have closing?
We don't have closing at the first day, but we
Just allow us a time.
okay, and then some time for division rebuttal. Okay. And then I think after that will be time for board questions of DRMS and the parties, and then providing the board an opportunity for deliberation. And I guess one question, and this kind of comes back to what Mr. Stills brought up, was an opportunity for some closing comments on that first day also, recognizing the board's about to go into deliberation. Is that something, I mean, I'd like to keep that to about 5 minutes apiece if you want some closing time on that first day. Is that of interest to either of those parties?
This is Travis. Yeah, and the board, and I'm not as familiar as others as far as being in the day-to-day hearings there. I've been in a few, but are there board questions during the presentation, or is that board questions strictly relegated till later in that time slot? I know the board can act at its pleasure, but.
Sure.
The answer is yes.
So that's kind of what I thought, but I didn't know if there's any, rigid rules being put on this that we should be aware of.
Yeah,
I would
really.
Yeah, not really. The board and stuff, if they have questions and stuff like that, they may ask during your presentation or at the end of your presentation, but also at the end, and that they may hold questions and stuff for a general conversation. So it just depends on what the subject is and their pleasure, really. But so it could happen either way. But time, if they ask questions, time doesn't count against you. Let's put it that way. If you're in the middle of your presentation or something, in that as a normal flow goes and stuff with our board hearings, that those questions by the board and stuff don't count against your time.
Okay, thanks. I appreciate that. And then to answer the question that was asked, yeah, I think, at least from our point of view, a quick 5-minute summation of position, not a I guess folks can use it as they want, but what we would anticipate is a closing statement. Here's what we think you should do, kind of a statement. Opportunity at the end, I think, would help the board know if there's just a serious question still remaining out there, or if everything to be taken care of. I think it would be helpful. We'd appreciate it.
Yeah, no, I think we could certainly do that. I think we've got the time in that first day to have a separate 5 minutes. So this will be 5 additional minutes to your hour to kind of wrap things up. Okay. And then really go into board questions and then board deliberation for the rest of the afternoon. So I think that gives the board sufficient time, hopefully, to ask some questions and then have adequate deliberation time. So that's kind of first day. I think we've got allocated, and like I said, I'll get a draft pre-hearing order out that reflects that. Any questions on that first day? Anybody uncertain about how we've laid things out? Okay. So day 1 is set. So day 2, we're going to be covering temporary cessation of production. And I know we have some additional parties on this that I think want to have an opportunity, or at least submitted some formal party comments. So I just, maybe first off, let me identify which parties want to have an opportunity on that second day to make a presentation. And I obviously, I think we still have the conservation group. We have CMA. I believe we also had comments submitted by NBEMCO. Are you interested in having formal presentation time?
Yes.
Okay. And then also DOE legacy management, do you want to have presentation time?
Brian, can you address that?
We weren't planning to present. We wanted to just make sure our comments were filed formally so that they were on the record. And we were going to leave it to the companies, I believe, to make any presentations.
Okay.
If you're okay with that, Debbie.
Great.
Yes, thank you.
Okay. Thanks. No, that's helpful. Anybody else that wanted comment time related to temporary cessation of production that I've not already mentioned? Okay. So we've just got the three parties on that second day that want time before the board. Let's see, do some quick math here. Sorry, just doing some math on the side here, thinking about time allocation. We've got a little bit more time on day 2 because we're not opening with director's reports, et cetera, like we will be on day 1. So I think on day 2, if we went with, I mean, and I'm basing this on the size of the submittals for the pre-hearing statement. So we had pretty sizable submittal from CMA and conservation group related to temporary cessation of production. The VEMCO, obviously you did submit, not quite as long. Does the VEMCO feel like you need the full allotment? Because I was kind of thinking a little bit less based on the amount of information you had submitted for your pre-hearing statement.
I think that's fair. In looking at what CMA has presented, many of those issues that I would have commented on were already covered. So I think that reduction of time would be appropriate. I will likely make most of my comments in the rebuttal stage. So that would be fine.
Okay. So if we're going based on kind of the first day, I'm still thinking if we did allocations of 60 minutes for both CMA and conservation group, and then for Nuvemco, 30 minutes. Does that seem appropriate?
That'd be fine.
Okay. Any thoughts from conservation group or CMA on the hour of time allotment?
Yeah, this is Travis. I'm fine with the hour. What I would suggest is what I've seen oftentimes is reversing the presentation order in rebuttal.
Yep.
And I didn't ask for it on 11-13 because I think those are pretty straightforward. But I think it would be appropriate to, if we're going first, especially both days, that we reverse the real order for rebuttal. And CMA and Nuvemco can decide who goes first there, but I think it would be appropriate for the conservation groups to go last and CMA go first on the rebuttal time. And I think it's commonly done as a matter of fairness.
Sure. Any objection to that by CMA or Nuvemco?
No.
No.
Travis, I think we'd been anticipating kind of flipping the order of presentations on day 2 as well. So it's not, you guys aren't batting first each day.
Yeah.
Oh, okay, so it'd be the same as the presentation and the, okay, no, that's fine.
Yeah. So we'll flip things on Wednesdays in fairness to all the parties. So on Wednesday or on Thursday, sorry, second day, what'll happen is we'll have DRMS introductory presentation first, have an hour for that, and then we'll have CMA go next with their initial presentation. and then Nuvemco. And then conservation groups would have their presentation at that point. And then we'll go into rebuttal with the same order. So that would be CMA rebuttal, Nuvemco rebuttal, and then conservation groups rebuttal. And then I think just like the first day, we'll go with the 5-minute closing statement following that from each of the groups in the same order. And then obviously there'll be a time for probably some board questions, and then the board can go into deliberation. Does that seem okay to folks? Any concerns?
Question, Mr. Chair. There were a number of comments in the CMA pre-hearing statement that I maybe don't fall directly within production and TC. Would I be correct to conclude that any non-1113 issues go to day 2?
I'll ask the division how you would like to.
Wednesday will be 1113 and general edits in that. So so that's part of the conversation and stuff on Wednesday. And we didn't articulate that very well and stuff at the start. So our apologies there. So, but yeah, Wednesdays 1113 and any general edits and then production and TC would be there. And then if there's something that we don't get covered and stuff like that, then we'll certainly have to address that and stuff like that towards the end of the process and stuff there. But wherever we can fit that in and those comments and stuff that if we have time and stuff on Wednesday to ensure that we get that done, that would be great.
Does that answer your question?
I think so. It's only comments and testimony that relate to the sections of the rule that are proposed for revision that deal with the definition of production and the TC provisions. I'll have to relook at the rule to see whether there's any ambiguities, Mr. Chair, but I think I'm understanding how you want to proceed.
Okay.
And hopefully on the general edits, we can reach a consensus before the hearing. And that leads me to a question. I don't know when you want to deal with this, but I remember in the stakeholder meeting that Russ Means chaired a week or two ago, there was I think Jeff described the having on the screen a red line version of the rule to allow the board to see and the parties to see if there are any revisions on which there's consensus among all the parties. And I'm wondering if you can speak to how that's going to unfold or how that could unfold during the hearing. Would there be sort of a report in the division's initial presentation that we've come to closure on these 3 things, and here's what's remaining? I'm just trying to plan ahead a little bit.
All right, this is Russ Means, and Jeff Hugate and myself we've had some conversations and stuff since the submittal of everybody's information, and we do see that actually there are several areas and stuff where all the stakeholders and stuff were close. So what we were going to propose and stuff at the end here, and that is possibly setting up a meeting with conservation and with CMA and that relatively quickly to have a discussion on that, and then maybe bringing all the parties together quickly so that we can possibly get consensus on a couple of those things that we're very close on to kind of help narrow this down. And that was going to be towards the end of the conversation and stuff, but right now it's fine to discuss that. So we don't have any dates or anything like that. We just wanted to see if there was any kind of interest in doing that. And if so, it's something that we can reach out today and that to try to set up some time for some discussion. That way we can, if we can get some things done so that when we pull the red line version up and we can say, all parties and stuff and that have consented to this a language or whatever, or whatever part of the rule is and stuff that will certainly help move that along. And that red line version will be up, and you'll be able to see that on the Zoom and stuff just as well as things are moving along. And that, obviously, I don't think the board's going to really care about the numbering systems or things like that, but we'll be able to go through very quickly and point out things and focus in on the 3 or 4 issues and stuff that we really need to talk about. So, are you, is CMA interested in having that conversation, say sometime early next week or sometime next week?
Certainly.
Okay.
Yes.
Mr. Stills, and that would that be something that you would be interested in?
Well, Jeff Parsons will be available then to take this meeting. He's more on the substantive lead of it. In practical terms, it seems to make some sense, but since we are in formal Colorado APA rulemaking, I don't have any solid view. I'm just always cautious about taking a public process out of the public eye. So I just want to make sure that both the board and the division council are comfortable with what you proposed.
Okay, yeah, and
I don't have a solid view on it. It's just my public interest radar comes up whenever there's a sidebar, and I'm not saying it's not a good idea. I just want to be cautious if we do it to make sure that it's an appropriate thing to do.
Certainly, and I'll let council step in here and something, but I think part of the conversation is if we can have a chat with each stakeholder side and then bring everybody together, there's that transparency and stuff that needs to occur there. So that, and then certainly everything and stuff that we have discussion on has to be presented to the board in a public forum and stuff as well. So it's a sideboard, but it's something that we've been doing through the informal process, but we do want to be as transparent as possible.
And as a public interest attorney, it's always my habit to ask that question. I don't have a formed opinion on it here today. I just, it's one of the things I note anytime we're going forward. So just appreciate you taking a look at it, and we'll do the same. It's just, I want to flag it. That's all.
Yes, sir. Thank you.
Yeah, Ed, Travis, kind of to your point, I mean, obviously, we have the process and the rules that we have to follow regarding notice and everything, but I would encourage your folks and CMA's folks, if you guys think you're close on some things, please, as they say, talk amongst yourselves. And, we don't necessarily have to be part of that process, and, would welcome you kind of reaching, well, this is what we think is consensus language. And, if you bring it back to us, and then, I think Jeff Fugate can, appropriately guide the division on how much they are involved in that process. But, I don't think anybody would be disappointed if you guys were able to come back to us and say, we think we've got some consensus language on these few points. What do you guys think? I think would welcome that.
Yes.
To do it. I just want to make sure we don't step on or over any kind of right line, formal rulemaking lines. That's strictly my comment is, and I do think that the intent of all of this is clearer than that is to deal with some very uncontroversial things and make sure that we don't spend a lot of time we don't need to spend in hearing on things that are actually resolvable and not controversial. So appreciate that. And I'll make sure Jeff's fully aware of how this went, and I'm sure he'll want to reach out.
Thanks for the discussion. Mr. Sanderson, I know you mentioned you had some other questions that you wanted to bring up. Was that was one? Are there any additional ones that
Well,
had?
Sure, thank you. The pre-hearing or the public notice required that all pre-hearing statements and rebuttal statements be in double face or double spaced in the 12-point font. And, we work to, and 15-page limit, and we work to stay within that. Not all the parties did that. The Inform group had a single page, 8-page submission. I think there was one other, maybe it's DOE, that I can recall, but I'm not here to object to their having submitted that, but I'd like to know what the rules are, because a 5-page rebuttal is pretty short, given the number of issues, and only 10 more days to pull that together. And so I want to know if you're going to enforce those rules, or you're going to extend the page limit for rebuttal. Those are the two questions.
Jeff Fugate.
And sorry if I'm going to jump in and maybe step on toes here. I mean, I don't think the division objects to, expanding the page limit on rebuttals. Again, as I said before, a lot of that was just so we're not flooding our board with a ton of paperwork, in short period before the hearing. And they'll review all of the material submitted. They generally will get all this information, I think, was it the 9th or so? So not a ton of time to review it. But with the number of parties, I think that if there's additional pages allotted to that rebuttal statement, Jeff Graves, I think you have the authority to modify that. I think the notice even indicates that it's subject to modification by board or hearing officer. I just don't know what page limit would be too much, or what's kind of a reasonable amount of additional pages for rebuttal, excluding attachments. And Jim, maybe you can give me a sense of a more reasonable page limit for the rebuttal, and does that include or exclude attachments? What's your request as far as more pages for rebuttal statements?
I would think if 15 pages double spaced was the pre-hearing statement, if rebuttals could be 8 and not including attachments or exhibits, I think that would be fair.
Yeah, I'm comfortable with that, making that modification, unless anybody has a significant issue with that. Mr. Stills?
No objection.
Oh, okay. Okay. Yeah, so we'll modify that to 8 pages with the double space, et cetera, requirements. So
Great.
I guess the other sort of housekeeping issue relates to the requirement in the pre-hearing order, or the public notice, that indicated that if you're suggesting alternative rule language, you also have to submit a concise proposed statement of basis and purpose language. CMA group did that. I don't think the Inform group did that. In other proceedings with other boards and commissions here in the state, the commissions have used flexibility in looking at that in terms of if it's clarifying or amplifying a proposal that's already in the proposed rule. We're not going to insist on providing a proposed statement of basis and purpose language to accompany it. So I don't know if the division, or if Jeff, or if Chuck, if you have a process or an approach to this issue that can guide the parties. Because I think if we are going to be talking and looking for common ground, that might entail developing statement of basis and purpose language to accompany any such amendments that we would ask the board to consider. So I just thought that clarification would be useful.
Any thoughts from anyone on that?
Yeah, Jeff Fugate, maybe I don't think we've really talked about, well, I know Jeff and I haven't talked about it, and so I don't, I don't have I don't have something ready to go in terms of here's our position and an outline on that. I think at least it strikes me as the sort of thing that we can get over. It's not an insurmountable hurdle here. If in particular, if we're talking about kind of consensus language that that gets hammered out before the hearing and the board agrees on it, we can figure out. I mean, it'd be nice to have something else to go into the statement of basis and purpose to cover a change like that. But I mean, I think it's sort of something we can deal with in the breach, in particular if it's a non-controversial issue. Jeff, what do you?
Jeff, you get.
Thanks. And Jim, maybe I want to make sure I understand your question before I kind of dive in with an answer. Is your question that conservation groups didn't provide kind of the outline of the requirements for alternate proposed rules as set forth in the notice, or is it just, does the board really want to see this language? I guess
there are 2 points. There are 2 points. One, I note that they did not provide a suggested statement of basis and purpose language, but they did have a list of proposed rule changes. So I'm not objecting to that, but I want to know how the rules are going to be enforced going forward.
Sure.
Because I think it's in the public interest for the board to consider these things, and then maybe in the informed group, that the coalition can supplement if they have statement of basis language they want to add to that. But I'm more interested in getting a result that holds together than complaining about it. And then the second question has to do with any consensus language that we come up with, that we probably ought to also be thinking about statement of basis and purpose language that would accompany that or support it.
Sure. Maybe I'll start with the second question first. I think to the extent that either the parties independently or parties working with staff come up with some consensus language, I think we'll modify or amend the SBP accordingly to make sure that, again, whatever the language is both within the scope of the notice rulemaking and that the board has the authority. And I think that's, the important part of that language in the notice is that for any new proposed language, that it has to fit within the scope, can't be outside the scope of these rules, and the board has to have the authority to promulgate the suggested rule. Turning to your first point, I can't speak for the board, and I don't know what they'll do with proposed language that doesn't have the accompanying SBP language, or just a resuscitation of, does this proposal fall within the scope, and does the board have the authority to promulgate that rule? Maybe that's, Travis, something you and Jeff could talk about. If it's again, in looking at your alternate language, it seems to be within the scope, but I think a statement of that coupled with authority would be helpful for the board. Whether the board is going to, hold firm to that requirement or not, I can't speak to that.
Great. Just for clarification then, I think the intent of a statement of basis and purpose and it being within the authority is within the narrative of the pre-hearing statement. So I think it has all the substantive pieces. But just for clarification, what you would like to see is a statement of basis and purpose under separate header filed as an attachment to the rebuttal.
It sounds like, and Jim, I don't want to put words in your mouth. Sounds like that would be helpful to, pluck if it does exist. I know in your pre-hearing statement, you do have a resuscitation of board's authority. If you can pluck it from that and drop it into a standalone document as part of rebuttal, I think that will help identify where the authority and that it's within the scope. That would be helpful. Again, just as the board is working through modifying the rules, they'll likely be modifying the statement of basis and purpose. They might add some additional discussion to some of the points to clarify kind of the intent behind a particular regulatory change. I know that the statement of basis and purpose that was filed with the Secretary of State was somewhat bare boned in that it identified what the changes were, but didn't provide a full discussion of the real intent behind that. And that's kind of the historic practice of DRMS is they typically wait for the board hearing to occur and get some direction from the board on the intent or purpose behind something. I think that rings true here, where a lot of these rules are dealing with, leaving some flexibility and discretion to staff to deal with some of these, case by case types of implementation, whether it's end date or TC related findings. But there will be aspect of this rulemaking that will be modifying that SBP. So any proposed language we have from you all, if it's associated with consensus proposals, we'll do some modifications to the SBP as well to be consistent there.
So did that answer your question, Mr. Sanderson?
Yeah, thank you.
Okay. Any additional thoughts or comments from parties? I mean, I'll run through again real quick what the order of things is, just so we're all on the same page. Anything else you want me to, or that we need to discuss?
I have two questions, if I may.
Okay, sure.
Has there been any thought given to holding the hearing in person?
I'll let the division speak to that.
The general format that we're having to follow and stuff is a hybrid meeting, and where the board is in person and staff. Part of that has to do with the limited availability of access to 1313. It is closed down, and in order to get people in and out and stuff, would require staff to be on hand and that to let people in and out, and it creates a logistical issue and stuff. We also haven't had any direction from EDO regarding lifting of any kind of restrictions and stuff as far as public meetings go, and that so this is put out as a hybrid meeting, and that's the general guidance and stuff that we've been given and stuff for all boards and that in the state of Colorado, is to try to do hybrid meetings as much as possible for a lot of reasons. So we are going to stick with the Zoom meeting and stuff and that for parties, and that based on those reasons.
Okay, thanks for that. One follow-up. So in order for me to keep to my time limits and keep my comments concise and directed to the board, I likely will want to use a PowerPoint. Do I need to provide that in advance to provide the written record that Mr. Fugate mentioned earlier? And if so, when would that be appropriate to provide?
You can, we'll work with the board administrator, Kenny Mojar, and that. But if there's a PowerPoint, you can certainly bring it up and use it. But any material and stuff that will be presented to the board during the board hearing needs to be part of that written record. So we either need to have it the day before or the day of the hearing. It could be sent by email to Cami, and I'll provide that email to all parties.
Very good. Hey, thank you much.
And Paul, for that, as long as you provide a copy of your final draft to staff, we'll make sure it's included in the administrative record on this one. So it's definitely not something you need to exchange in advance of the hearing. I mean, you can just send it when you're done presenting, or that Thursday evening after the hearing concludes.
Okay, great, thanks. And while I got the mic, thanks to everyone for all the effort they put into this over the past few years.
The fact that it's been a few years and stuff is frustrating, but we're getting there. So.
Okay.
Can I follow up on Paul's statement about the PowerPoints?
Yeah.
Some of these platforms allow what they call screen sharing, so that Paul could put his PowerPoint up and walk through it. Other platforms require somebody on your end that's in the hearing to move the slides from 1 to 2 to 3 to 4. Which do you know which it's going to be?
You will be responsible for your presentations, so you'll share your screen and do your presentations, and that we just need a copy of that for the formal record. So, but you will be responsible for your presentations, not staff or someone from the board.
Thank you.
Again, we'll be using this Zoom platform. It's the platform the board is most familiar with. Yeah, unlike other boards, you will have, I mean, it's a small group, or maybe we just trust you all a little more than other agencies. You'll be in control of your own screens. You'll have the ability to kind of mute and unmute yourself when it's your turn to speak. Kemi Mohar, who kind of runs the hearings, it's generally a little too much for her to manage people's presentations and all of the other stuff that pops up during the hearings. To give you guys a sense of what's going on in the board hearing room itself, for those that are appearing virtually, and I know that Russ, you and your team are kind of putting the board room together. There will be big TVs in the boardroom so that the board can see all of the presentations as well as people presenting. They'll also have their own laptops where they'll have access to all of the materials. So they'll be able to follow along with the hearing and see everybody. Not the same as everybody in person, but they will have some additional monitors in that hearing room to make this hearing a little more accessible, and the board will be able to follow things a little better this time.
I'll go ahead and run through just a quick summary on where we ended up for each day with time allotments, just so we're all on the same page. Day one, we're going to be discussing 1113. We're going to start with 30 minutes of non-party comment. Then we have 1 hour of DRMS presentation. And then we will go into a conservation group presentation. And as mentioned before, we will have 1 hour block that those groups can use in both their presentation and rebuttal. So it'll be conservation group first, then CMA. And then that will be followed by rebuttal with conservation group and CMA and division.
1113 and general edits.
Yes. Just Russ clarified that on Wednesday, that will be 1113 and general edits that we'll be discussing on Wednesday. My apologies. And so we'll have those closing statements following rebuttal, and those will be 5 minutes each for conservation group, CMA, and division. And then we'll go into board questions and deliberation. So that's day one. Day two, we'll be discussing temporary cessation of production. Start off with half an hour of non-party comment. Then we'll have DRMS presentation. That'll be an hour introduction. Then we will have, as mentioned before, 1 hour time blocks that the parties can use for both presentation and rebuttal. We'll be starting with CMA first. Then we'll have the VEMCO, and I apologize, the VEMCO, we have 30-minute time block total. And then we have conservation groups. That will be followed by rebuttal in the same order. So that'll be CMA, New VEMCO, conservation groups. And then we'll have closing statements, where we'll have 5 minutes each for closing statements for all those parties in the same order, and the division. And then we'll have an opportunity for board questions and board deliberation at the end of the day. So I think the total amount of time allotted for each day for those discussions was 3 hours and 45 minutes on day one, and 4 hours and 20 minutes on day two.
Mr. Chair, would you run through the times again?
Sure.
My connection cut out, so it was 30 minutes for the non-parties, and then would you proceed through that for me quickly?
For both days or just day?
No, just day two.
Okay, day two, sure. So 30 minutes for non-parties, then we had an hour for DRMS presentation. And then we have the 1 hour time block for CMA that can be used, obviously, in presentation and then rebuttal. It will be CMA. New VEMCO has 30 minutes total time block. And then we have conservation groups with an hour. That's followed in the same order by rebuttal for whatever's remaining of that hour time block, with CMA, Uvemco, and conservation groups. And then we have 5-minute closing statements by all parties following that, including the division.
Thank you.
Any additional questions or comments? I guess I do want to just mention real quick the remaining, just so it's on everybody's mind, the remaining submittal timelines. We have non-party written statements due May 2nd. We have formal party rebuttal statements due May 5th, and that does include the increased 8-page limit. May 9th, we have non-party requests to comment at hearing. Those are due. And then the board meeting obviously is on May 18th and 19th, beginning at 9 a.m. on May 18th. Mr. Stills, you had a question?
Yeah, I did have one question, and my apologies if Jeff, being more familiar with it, knows this. When the board closes the hearing and goes into deliberations, is that a hard line? Some boards and commissions have that. Once the public record and the party's comment is closed, the board can't come back to open public comment again. How does this board typically handle that, and how are we handling it here? Is it a hard shut off of our mics and just amongst the boards, or do they have the opportunity to bring folks back?
This is,
Yeah, I was going to say, we usually start with the position that once it's closed, it's closed. This board occasionally will need to ask another question, so it's not unheard of for them to open it back up. But our starting position is once testimony is closed, that's it, and they're moving into deliberation. But with the caveat that it's happened in the past in different hearings where deliberation will bring up another question and the board will want to ask.
Okay, thank you. I appreciate that.
A follow-up on that question. Day one is deliberation on the day one subjects. I've seen commissions reach a preliminary tentative conclusion on where they are at that point. Then they go to day two, hear the evidence, and then they deliberate there. And then they bring forward the deliberations from day one, and they leave themselves the option to reopen and adopt something in final at the end. Can you speak to whether any of those scenarios is what you have in mind?
Yeah, go if you want to go ahead, Russ.
Okay, well, Chuck, go ahead and start there if you want. So.
Yeah, I mean, I don't think we're anticipating having the board vote to adopt changes kind of formally at the end of day one. I mean, I think our anticipation and expectation is it's going to be more along the lines of, they're going to carry forward what they what they agree on day one, and then it gets rolled into kind of the final adoption of everything at day two. I wouldn't expect them to open something from day one back up on day two, but with the exception of somebody sees a glaring typo, over lunch for some odd reason, and we've got to change, subject verb disagreement or something. I wouldn't anticipate that at the end of day two that they're going back to sort of the language that everybody settled on at day one. But, having said that, there's also not going to be a formal vote to adopt those set of rules that are discussed on day one at the end of day one.
Thank you.
Anything else from folks? And I don't see any hands raised. I appreciate your time this morning, working to be concise on time allotments and your suggestions related to the order of presentations and rebuttal, et cetera. So appreciate your thoughts and comments, and Like I mentioned before, hopefully I'll have the draft pre-hearing order out next week. And that, as mentioned before, may be revised additionally based on how many non-party commenters request time before the board and any additional items that come up kind of during that period of time. So, okay. I think we're done for today. Appreciate your time.